My husband moved in with his mistress and took our children, telling the court that I was a bad mother. His lawyer was smiling, but at the court hearing, I silently stood up and said 3 words. The judge stopped the hearing. Good day, dear listeners. It's Briella again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way, I can see how far my story has traveled. People always said Daniel and I looked like the couple from a catalog, the kind of photo they put on the wall of a furniture store. Matching smiles, 2 kids, a golden retriever named Biscuit we probably didn't need. We lived in Naperville, Illinois, in a house with a blue front door that I had painted myself the summer after Emma was born. I remember standing on the porch ladder, 7 months pregnant, Daniel laughing from the driveway telling me I was insane. I laughed too. That was 11 years ago. My name is Rachel Mercer. I was 38 years old when my life cracked open like a dry riverbed. I worked part-time as a dental hygienist, Tuesday through Friday, because that schedule fit around Emma's school drop-off and Tyler's speech therapy appointments. Tyler was 7 then. Emma was 9. They were the architecture of every decision I made. Every single one. I should have seen it coming. I think a part of me did. In the way you sense a storm before the sky changes color, there's a pressure in the air, a quality of silence you can't name. Daniel started working late in February. Not every night. That would have been too obvious. Just enough. 2 nights a week, then 3. He came home smelling like he had just showered at the gym, which was strange, because Daniel hadn't been to a gym since 2019. He started keeping his phone face down on the kitchen counter. He started laughing at things on his screen and tilting it away when I walked past. Small things, catalog smile things. I told myself it was stress. He'd been passed over for a promotion in January. I told myself I was being paranoid. But I am a woman who pays attention. It's practically a professional requirement. You spend your days looking into mouths, finding the tiny dark spot before it becomes a cavity. You learn to look closely. I started noticing the charges on our shared credit card around April. A restaurant I didn't recognize, Fiore on Michigan Avenue in Chicago, $42 for lunch on a Tuesday. Daniel had told me he'd eaten a sandwich at his desk. A hotel confirmation email that I only glimpsed because his laptop was open on the kitchen table, and the subject line loaded before the screen timed out. I didn't click it. I should have. Instead, I closed the laptop and stood in my kitchen for a long time, staring at the blue front door from the inside. I didn't confront him yet. I want to be honest about that. I was afraid of what he would say, and I was more afraid of what I would lose if he said it. So I kept making school lunches and driving Tyler to speech therapy and smiling at Daniel over dinner. And the whole time something cold and very quiet was settling in my chest, like sediment in a glass of water. Her name was Crystal. Crystal Howe. I didn't know that yet. I found it out later, in pieces, the way you find out everything that matters, too slowly, and then all at once. What I need to tell you first is how it ended, because the ending is the reason I'm still standing. I need to tell you about the courtroom. It was a Tuesday in October. The fluorescent lights in Cook County Family Court have a particular quality, flat and merciless, like light in a hospital. I was sitting at a table across from Daniel and his attorney, a man named Gregory Holt, who had white teeth and a gray suit, and who smiled at me like I was something minor and manageable. Daniel had filed for full custody of Emma and Tyler 3 weeks earlier. His petition stated that I was emotionally unstable, that I had neglected the children's medical needs, that Tyler's speech delays had worsened under my care. Every sentence was a lie constructed from the bones of something true. A rearranged fact, a date changed, a context stripped away. I had sat through 40 minutes of Gregory Holt presenting his case. I had listened to Daniel describe our life together in a language I didn't recognize, watched him speak calmly and sadly, performing grief like a man who had practiced in a mirror. I had watched Gregory Holt smile, and then something shifted inside me. I stood up. The judge, the Honorable Patricia Wynne, looked at me over her reading glasses. I said 3 words. "Check the timestamps." Judge Wynne raised her hand and stopped the proceeding. That moment is where this story ends. But to understand what those 3 words meant and why they stopped everything, you need to understand what came before them. You need to understand how a woman who painted her front door blue while 7 months pregnant learned to fight in a language the law could hear. Let me start from the beginning. I found out about Crystal Howe on a Thursday evening in May, when Emma had a sleepover at her friend Maddie's house, and Tyler was asleep by 8:30. Daniel was working late. That phrase had become a kind of shorthand between us, a word we'd both agreed to pretend was real. I sat down at the kitchen table with a glass of water and his open laptop, and this time I didn't close it. I want to be clear. I am not a person who goes through other people's things. I had never read Daniel's messages before that night. I'd like you to understand what it took to cross that line, because it matters. It means I already knew. It means I wasn't looking for proof. I was finally letting myself look at it. What I found took me about 20 minutes to piece together. A Gmail account I hadn't seen before logged in on his secondary browser. Messages going back 9 months. Her name was Crystal Howe. She was 31. She worked in his office, in the project management division. Her profile photo showed a woman with straight blonde hair and very white teeth, the kind of person who looks assembled rather than grown. The emails were intimate and specific, and they described a life he was living in parallel to mine. Hotel rooms, restaurants, weekends he'd told me were work conferences. She called him my Daniel. He called her my future. I read that phrase, my future, and I felt something leave my body. I didn't cry right away. I went to the bathroom and ran cold water over my wrists, which is something my mother used to tell me to do when I was overwhelmed. Then I went and stood in the doorway of Tyler's room and watched him sleep. His mouth was slightly open. He was holding the corner of his blanket the way he'd done since he was an infant. Emma's room was across the hall, her nightlight still on even though she wasn't home, because she always forgot to turn it off. I stood between their 2 doorways for a long time. Then I walked back to the kitchen and I closed the laptop very carefully, and I sat down and I thought, this is the part that people don't tell you about betrayal, that after the initial impact, there is a window, a strange, cold, clear window where you can see everything very precisely before the grief arrives. I was inside that window, and I knew it wouldn't last, so I used it. What did I actually have? I had access to his email. I had names, dates, and a paper trail on a shared credit card. I had the knowledge that this had been going on for 9 months. What I didn't have yet was a plan. What I needed to understand first was what I stood to lose. I'm a dental hygienist working part-time. Daniel is a senior engineer at a logistics firm making $112,000 a year. The house was in both our names. The children's primary caregiver had been me, functionally, for years. Every school form, every pediatric appointment, every sick day and school play and nightmare at 2 a.m. that was documented in nothing. That lived only in the texture of daily life, invisible to any court. That was the first thing I understood. Invisible labor is invisible to the law unless you make it visible. I didn't tell Daniel what I knew. Not yet. I kept making dinner. I kept driving Tyler to speech therapy, which was every Wednesday afternoon with Dr. Patricia Flores at a clinic on Washington Street. I kept smiling at Daniel over dinner with a face that had learned, apparently, to perform normalcy under pressure. I was running on a kind of cold autopilot that frightened me slightly, but I didn't let it stop me. The first thing I did was open a new email account on my phone, a personal device Daniel had no access to. The second thing I did was begin photographing documents. I photographed our joint financial records, the credit card statements, the mortgage papers. I went through the filing cabinet in the home office, the physical one, the one with the hanging folders, and I documented everything. I didn't take anything. I photographed and replaced. The third thing I did was call my sister Diane in Columbus. Diane is 3 years older than me and has the kind of calm that comes from having been through difficult things. She'd been through a custody dispute herself 8 years ago, and she'd come out the other side. She listened to me for 40 minutes without interrupting, and then she said, "Rach, you need a family law attorney before you say a single word to Daniel. Don't move. Don't confront. Don't telegraph. Get a lawyer first." I had been thinking the same thing, but hearing her say it out loud made it real. I found Margaret Osei the following Tuesday. She came recommended through a legal aid referral, a family law attorney in her 50s with an office in downtown Naperville, a woman who wore reading glasses on a chain and spoke in complete sentences and did not waste words. I told her everything. She listened, made notes, and then looked at me with an expression I can only describe as professional compassion. "The custody situation is your most urgent concern," she said. "Everything else follows from that." She was right. I just didn't know yet how right. Margaret's first instruction was simple and absolute. Begin documenting everything that related to the children. Not Daniel's affair. That was relevant, but secondary. What mattered in a custody case, she explained, was the parenting record. Who took the children to school? Who attended their medical appointments? Who managed their daily lives? "Family court doesn't care about moral grievance," she said at our second meeting, which was at 8 in the morning before Tyler's Wednesday therapy. "They care about the best interests of the children. You need to prove that primary caregiver is you, not in your memory, on paper." So I started building paper. I began keeping a daily log in a small notebook I kept in my purse. Date, time, activity. Tyler speech therapy, Dr. Flores, Washington Street, 3:15 to 4:15 p.m. Rachel present. Emma school pickup, 3:45 p.m. Rachel present. Tyler pediatric well visit, Dr. Hogan, May 22nd. Rachel present. Every receipt. Every appointment confirmation email forwarded to my private account. I requested copies of both children's school records and medical files through official channels, in my own name, establishing a documented history of involvement. It felt bureaucratic and strange to be cataloging the acts of love that had simply been my life for 9 years. But Margaret had said it clearly. The law sees what is written down. So I wrote it down. Daniel noticed the change, though I'm not certain what he noticed exactly. He started watching me differently. Not with guilt. Daniel had always been capable of extraordinary compartmentalization, but with a kind of wariness I hadn't seen before. He came home on time twice that week. He asked about Tyler's session with an attentiveness he hadn't shown in months. He was recalibrating, and I understood that somewhere in his calculation, he had detected a variable he couldn't yet name. I was careful. I didn't confront. I didn't change my tone. I kept the domestic surface of our life intact, like a stage set, functional, convincing, hollow. What I did change was small and deliberate. I opened a personal checking account at a different bank, funded with money from my paychecks that had previously gone directly into our joint account. Margaret had told me this was legal and advisable. I did not move joint funds. I simply redirected my own income, $460 a week after taxes, into an account Daniel couldn't see. It was the second week of June when Daniel stopped coming home for dinner 3 nights in a row without adequate explanation. It was the third week of June when I received a notification from our shared credit card that a charge had been declined. And when I looked at the account, I found that the available balance was $9,000 lower than it had been the previous month. He'd taken the money in cash withdrawals, $500 at a time, spread across 6 weeks. I had been so focused on building my own record that I'd nearly missed him building his. I called Margaret immediately. "He's preparing," she said. "Get ahead of it." The proof came on a Friday afternoon in late June. Tyler had a half day at school, and I had picked him up early. We stopped at the pharmacy on Oak Street for his allergy medication, and when I walked past the window of the coffee shop next door, Groundwork, the one with the green awning, I saw them, Daniel and Crystal Howe, sitting across from each other at a corner table. Not romantic movie intimate, but domestic intimate, the kind that's worse. They were looking at papers spread across the table between them. Daniel had a pen. She was pointing at something on one of the pages, legal documents, from the shape of them. She was wearing a blazer. Tyler was holding my hand and asking if he could get a popsicle from the pharmacy. I looked through the window for exactly 3 seconds. Then I looked away. I said, "Yes, buddy, let's get a popsicle." And we went into the pharmacy, and my heart was hammering so hard I could feel it in my fingertips, but my face was still. I texted Margaret from the pharmacy parking lot. He's with her reviewing what look like legal documents. "Do I photograph through the window?" She replied within 4 minutes. "No, don't engage, don't approach, don't photograph from the street. Note time, location, and description. We have other avenues." Those other avenues turned out to be more significant than I expected. The following week, Margaret told me she had engaged a forensic financial analyst who had found something in the credit card records I had photographed, a pattern of charges at a specific hotel in Chicago, the Langham on Wacker Drive, spanning 8 months. The hotel had a record-keeping policy. Those records were obtainable through legal discovery in a divorce proceeding. And then Margaret told me the other thing. "One of the charges at the Langham," she said, keeping her voice level, "was on the night of December 12th, which was the night Daniel told you Tyler had a fever spike, and he was monitoring him at home while you worked the Saturday shift." I sat very still. Tyler had not had a fever in December. I had the pediatric records to prove it. Daniel had left our 7-year-old son alone in the house to spend the night with his girlfriend. I didn't say anything for a long moment. "Rachel," Margaret said quietly, "that's the point of no return." She was right. And I had known somewhere deep in the cold, settled place in my chest, that something like this was coming. That the man I had painted a blue door for was capable of this. The grief, when it finally arrived that night, was brief and very clean, like setting something down that had been too heavy for too long. I filed for divorce on a Monday morning in July. Margaret filed the petition at the Cook County Courthouse, and by that afternoon, a process server had delivered the papers to Daniel's office. He called me 47 minutes later. I was in the car outside the grocery store when my phone rang. I looked at his name on the screen and I let it ring twice before I answered. Rachel. His voice was flat, controlled. I recognized that tone. It was the voice he used in arguments when he was deciding whether to be reasonable or not. Daniel, I said, what is this? You've been served, I said. You can talk to your attorney. There was a pause. I don't have an attorney. You will, I said, and I hung up. He came home that night. I had expected that. He sat down at the kitchen table while the children were watching television in the other room, and he spoke in a low, measured voice about how we could handle this privately, how court wasn't necessary, how he was willing to discuss terms. He used the word amicable 4 times. He looked at me with an expression designed to suggest that he was the rational one, that I was the volatile one, that this could all be kept calm if only I would cooperate. I said, talk to your attorney. He left the kitchen. I heard him on the phone 10 minutes later in the bedroom, speaking too quietly for me to hear the words, but not too quietly for me to hear the tone. Urgent, instructive. He was calling Crystal. She called me 2 days later. I was at work between patients when an unknown number came up on my phone. I almost didn't answer. Rachel. Her voice was careful and warm, the kind of warm that requires effort. This is Crystal Howe. I think it would be good for us to speak. I have thought about this conversation often since. What she said was reasonable on its surface, that she cared about Emma and Tyler, that she didn't want this to become a war, that Daniel had told her how much I'd given to the family, and she respected that. She used all the right words. She sounded rehearsed, but not robotically so, which suggested she was intelligent. I'm not sure what you think you know about his finances, she said, but I want you to understand. Daniel has documentation that tells a different story than what your attorney may have presented to you. There it was. I'd encourage you to think carefully, she continued, before you make claims you can't support. It could affect how the court views your credibility. It could affect the children. I let her finish. Then I said, Crystal, I'm going to need you to not call me again. If you'd like to communicate, please direct everything through my attorney. I gave her Margaret's firm name and hung up. I sat in the break room for 2 minutes. My hands were shaking slightly. Not from fear, exactly, from adrenaline, from the recognition that the threat had arrived early, which meant they were scared. The documentation Daniel claimed to have materialized 3 days later, through Gregory Holt, a man who had apparently been retained within a week of receiving my divorce petition, which told me the preparation had started before my filing. Holt sent a letter to Margaret outlining Daniel's position, that I had a history of emotional instability, evidenced by a 2019 incident in which I had voluntarily sought therapy after a period of postpartum anxiety following Tyler's birth, that I had reduced Tyler's speech therapy sessions without medical authorization, and that I had, on several occasions, left the children unsupervised while working evening shifts. Every item was a distortion. The 2019 therapy was real. I had voluntarily sought help, which is not evidence of instability, but of health. The speech therapy sessions had been reduced on Dr. Flores's recommendation, documented in her notes. The evening shifts were 2 per month, maximum, and the children had been with Daniel, who was their father. But I understood immediately what he was doing. He was building a narrative. He was assembling the pieces of my normal life into a portrait of dysfunction, and in the hands of a skilled attorney, those pieces could be convincing. "He's going to petition for custody," Margaret told me. "We need to get ahead of him." 2 weeks later, he did exactly that. Gregory Holt filed a motion for temporary full custody of Emma and Tyler, citing the same list of concerns, dressed now in legal language and attached to declarations. Daniel had also filed a financial statement that dramatically understated his income and omitted the cash withdrawals. I requested an emergency meeting with Margaret. She spread the papers across her desk and we went through them line by line. Then she looked at me and said the thing I needed to hear. "He's overplayed his hand. This is aggressive enough that it's going to invite scrutiny, and scrutiny is what we want." That week, I allowed myself 3 days. I drove to Columbus and stayed with Diane. I slept in her guest room under a heavy quilt, and on the second morning, I sat at her kitchen table and cried for approximately 40 minutes. Ugly, full-body crying, the kind I had not permitted myself since this started. Diane made coffee and didn't say anything, which was exactly right. Tyler and Emma were with Daniel under the temporary arrangement, and not having them there was the worst physical sensation I have ever experienced. An absence like a wound. But by the third morning, I was steady again. I called Margaret from Diane's porch. I told her I was ready. She said, "Good, because we have work to do." When I drove back from Columbus on the 4th morning, Daniel's car was in the driveway. This surprised me. The children were still technically with him under the temporary arrangement, and he had no reason to be at the house. I sat in my car for a moment before getting out. He was sitting on the front steps, our front steps, at the blue door. He was wearing a jacket I had given him 3 Christmases ago, which I don't think was accidental. "I need to talk to you," he said. Not aggressive, quiet. He looked tired. I noticed, with a strange detachment, that he had lost weight. I stood on the walkway with my keys in my hand and waited. "I made mistakes," he said. I'm not proud of what I did, and I don't want this for the kids." "Emma cried at dinner last night. Tyler asked me when you were coming home." Something tightened in my chest at that. He saw it, and I knew he saw it, and I knew that was the point. "I am not asking you to take me back," he continued. "I am asking you to consider a private settlement. Joint custody, equal time, no court involvement. We could have something finalized in 30 days. The kids would be back home with you by next week." He slid a manila envelope across the step toward me. "Gregory put together a framework. I think you'd find it fair. More than fair, actually." I looked at the envelope. I thought about Tyler asking when I was coming home. I thought about Emma crying at dinner. I thought about the credit card charges at the Langham on December 12th, and my 7-year-old son in an empty house. "I'll have my attorney review it," I said. He looked up, something cautiously hopeful crossing his face. "Along with everything else she's reviewing," I finished. I picked up the envelope and went inside. Margaret called me after she reviewed it. Her voice had that particular quality it got when she was carefully managing her tone. Rachel, this settlement would give Daniel primary physical custody with you having alternating weekends. I went very still. He's framed it as equal, she continued. But the language in Section 4 defines the primary residence as his address, and Section 7 gives him educational decision-making authority. It's not equal. It's a document designed to look generous while legally establishing his primacy. Of course it was. What struck me was not the betrayal of the offer. I had expected something like this. What struck me was the clarity with which I saw it. 6 months ago, I might have read those words and wanted so badly to believe they were true that I would have. Now I read them the way Margaret read them, as language, as strategy, as architecture designed to contain me. Decline it, I said. I already drafted the response, Margaret said. I just needed your confirmation. I started to build something in those weeks that I hadn't had before. A visible support network. Margaret had explained that in custody proceedings, social context matters. Who shows up for you? Who can speak to your character and your parenting? Not as formal witnesses yet, but as a foundation. I called Julia first. Julia Park had been my closest friend since our daughters were in the same kindergarten class, a Korean-American woman who taught high school chemistry, and who had, on approximately 200 occasions, seen me parent my children with patience and love. She came over on a Tuesday night with wine and leftover japchae and said, I will testify to anything they need, before I had even finished explaining the situation. I reconnected with Dr. Patricia Flores, Tyler's speech therapist. She had been professionally circumspect during the marriage, as she should have been. But now, as my child's documented care provider, she was willing to confirm in writing that I had attended every single session Tyler had ever had, and that the reduction in session frequency in March had been her clinical recommendation, not negligence on my part. I joined a divorced and divorcing parents support group that met Thursday evenings at a community center on Jefferson Street. I did not expect it to be useful. It turned out to be essential, not because it gave me strategies, though it did, but because it put me in a room every week with other people who had been lied about in courtrooms and who had survived it. There was a woman named Lorraine whose ex-husband had accused her of alcoholism. There was a man named David whose ex-wife had relocated to another state with their son without notice. They had come through. They were still standing. On the Thursday, I attended my third group session. I drove home through the quiet residential streets of Naperville, and I thought about what it meant to be seen. Not rescued. Seen. Julia saw me. Dr. Flores saw me. The people in that Thursday circle saw me. The law could not yet see me, but the record I was building would make it. I thought, how do you prove the life you've been quietly living? And I thought, one document at a time. Crystal, meanwhile, had stopped calling. I knew through Margaret that Holt had advised her to maintain distance, but I was aware of her presence the way you're aware of something standing just outside your peripheral vision, a stillness where there should be movement. She was waiting to see what I would do next. I was fine with that. Let her wait. I was not in a hurry. I was in a process. The cold quiet in my chest had settled into something different. Not grief anymore, and not anger. Something more like resolve. A kind of temperature that doesn't fluctuate. I had an appointment with Margaret on Friday. She had something to show me about the financial records. I slept soundly that night for the first time in weeks. They came together. That was the part I hadn't anticipated. It was a Saturday afternoon in August. Emma and Tyler were back with me for the weekend. The temporary custody arrangement had been modified slightly after Margaret filed a counter motion, and I had them Friday evening through Sunday evening. We were in the backyard, the three of us, Tyler kicking a soccer ball against the garden fence, while Emma read on the porch step. It was the kind of afternoon I had been holding on to in my memory during the weeks they'd been away. Ordinary, warm, hours. I heard the front doorbell from the backyard. I went through the house to the front door and opened it. Daniel stood on the porch. Crystal Howe stood slightly behind him and to the left, wearing a pressed linen shirt, her hair smooth, her expression calibrated to something approaching concern. She was holding a paper bag from a bakery, the kind of detail that tells you everything about how a person has prepared for a conversation. "Rachel," Daniel said, "we need to talk. Can we come in?" I looked at him. I looked at her. I thought about my children 10 feet away in the backyard. "No," I said, "we can talk here." A flicker of something crossed his face. Impatience, recalibration. He nodded. "Okay, that's fine." He put his hands in his pockets, which is what he does when he's deciding to be reasonable. "I want you to understand that what we're asking isn't adversarial. We care about Emma and Tyler. Both of us do." Crystal's expression didn't change. Her eyes were doing something careful, assessing me, measuring the effect of their presence together. "Gregory has presented evidence to the court," Daniel continued, "that we think, when examined in full, is going to paint a picture that neither of us wants the children to have to live with. There's still time to resolve this before it becomes a public record." "What evidence?" I said. He hesitated. And in that hesitation, I heard the structure of what was coming. "There are text messages," he said, "from 2020, during the postpartum period. Things you wrote to your sister that, taken in context, could be misread. Private messages between me and Diane, from the hardest months after Tyler's birth, when I had been exhausted and frightened, and had said honest things to my sister about how difficult I was finding it. Nothing dangerous. Nothing that would concern a reasonable person. But in the hands of a skilled attorney, stripped of context, presented to a judge as evidence of a struggling mother, I understood. "Where did you get those messages?" I asked. He didn't answer that directly. "The point isn't, where did you get them, Daniel?" Another hesitation. Crystal shifted her weight. The bakery bag crinkled. "Rachel?" she said, stepping forward slightly. Her voice was modulated, reasonable, the voice of a woman who had thought about this conversation in advance. "We're not here to threaten you. We genuinely want what's best for the kids. But you have to understand, if this goes to a full hearing, both sides are going to present everything they have. It becomes a spectacle. It becomes something Emma and Tyler have to carry." She paused. "Whereas if you accept a reasonable arrangement now, we can all move forward. The kids stay with Daniel during the week. You have weekends and holidays, and we all agree to co-parent respectfully. It's not a loss, Rachel. It's a resolution." I looked at her for a long moment. I thought about the fact that she had come to my home on a Saturday afternoon with a bakery bag, that she had stood slightly behind Daniel when I opened the door so that I would see him first, that she was using my children's names. I thought about December 12th. "You left a 7-year-old boy alone in this house," I said. My voice was level. The air on the porch changed. Daniel's jaw tightened. Crystal's expression went still in a different way. The careful warmth went out of it, replaced by something flatter. "That's not what happened," Daniel said. "I have the hotel records," I said. "I have Tyler's medical records from that month. I have your credit card charges. I have your email account. I paused. You should have your attorney look at everything before you come to my door trying to negotiate with baked goods. The last pretense dropped from Daniel's face. What replaced it was not rage. He was too controlled for rage in this context. But something colder. A reassessment. You're making a mistake, he said. Maybe, I said. Close the gate on your way out. I went back inside. I locked the front door. I stood in the hallway for a moment with my back against the wall, and yes, I was afraid. Not paralyzed, not helpless, but genuinely afraid, because I knew what I had just done. I had shown them the edges of what I had, and they would now prepare for it. The hearing was 6 weeks away, but the fear was also, strangely, fuel. It clarified things. It reminded me what was at stake and why I had started this and what it would mean to stop. I went back through the house and out to the backyard. Tyler had abandoned the soccer ball and was lying in the grass looking at the sky. Emma had put her book down and was doing the same. What are you looking at? I asked. Clouds, Tyler said. That one looks like a submarine. I lay down in the grass between them and looked up. It does, I said. It absolutely does. The custody hearing was scheduled for a Tuesday in October. The Honorable Patricia Wynne presiding. I had not slept well the night before, but not from fear. From a kind of alertness, a heightened awareness of every detail. The clothes I had chosen, navy, simple, professional. The folder Margaret had prepared. The specific documents I had memorized so thoroughly I could have recited them. Julia had texted me at 11 p.m. You have this. I'll be thinking about you all day. Diane had called in the morning and said, Call me the second it's over. The Cook County Family Court building on Washington Street is older than it looks from the outside. Inside, the hallways are narrow, and the light is institutional. That flat, neutral fluorescence that flattens everything into equal severity. I arrived 40 minutes early and sat with Margaret in a small conference room going over our structure one final time. He will present first, she told me. Holt is good. He'll be calm, organized, and persuasive. Let him finish. Don't react. The reaction is what they're watching for. When it's our turn, we'll be methodical. I nodded. The text messages, I said. I've already addressed that in our pre-trial filing. The context issue has been flagged for the judge. But Rachel, she paused. They're still going to put them in. Holt knows they won't be dispositive, but he wants them in the room. He wants the judge to have read them. I know, I said. Are you ready? I thought about Tyler asking when I was coming home. I thought about the cloud that looked like a submarine. Yes, I said. The courtroom was smaller than the ones on television. Dark wood paneling. A large window overlooking a parking structure. Daniel and Gregory Holt were already seated when we entered. Daniel was in a charcoal suit I had never seen before, new, deliberately so. Holt had white teeth and a gray suit, and the settled confidence of a man who had done this many times, and expected to do it successfully again. Daniel did not look at me when I sat down. Holt presented his case over approximately 40 minutes. He was methodical and persuasive, as Margaret had predicted. He submitted the therapy records from 2019, contextualized as evidence of a pattern, not an isolated moment of healthy help-seeking. He submitted the text messages between me and Diane from the postpartum period, reading 2 passages aloud in a voice designed to convey concern rather than cruelty. He submitted a declaration from a neighbor named Paul Garrett, who stated he had once seen my car absent from the driveway on a school night until after 9 p.m. He referenced Tyler's speech delays with language that implied negligence, carefully, just inside the line of defensibility. He was good. He built a picture that, if you didn't know the facts behind each piece, was plausible. I watched Judge Wynn take notes. She was a woman in her 60s, small, with reading glasses on a chain very similar to Margaret's, and an expression of total professional neutrality. She gave nothing away. Then Margaret stood. She began with the parenting log. 14 weeks of documented daily involvement, every school pickup, every medical appointment, every therapy session, every teacher conference. Each entry cross-referenced with receipts, school sign-in records, and medical appointment confirmations. She submitted Dr. Flores's written statement, which confirmed my attendance at every single one of Tyler's speech therapy sessions, and which included Dr. Flores's clinical note dated March 14th, recommending a reduction in session frequency based on Tyler's measurable progress. She submitted the pediatric medical records for December, confirming that Tyler had had no documented illness that month. Then she submitted the hotel records. Langham, Chicago, Wacker Drive. Check-in, December 12th. Room charged to Daniel Mercer's credit card. She placed these alongside the credit card statement I had photographed in May, which showed the matching charge. She submitted the broader pattern. 8 months of hotel charges on dates that corresponded with Daniel's stated work obligations. Judge Wynn's pen stopped moving. She looked up, and then Margaret said, quietly and precisely, "Your Honor, we would ask the court to note the metadata of the financial declaration submitted by Mr. Mercer's counsel, specifically, the creation timestamp and the last modified timestamp of the document." She handed a printed exhibit to the clerk. The declaration was submitted to this court as an accurate representation of Mr. Mercer's current financial standing. However, the document's metadata shows it was originally created on February 22nd of this year, 2 weeks before any divorce filing, and was last modified 9 days ago, 4 days after our pre-trial submissions. The declared income figure differs from the version traceable through W-2 records by approximately $23,000. Holt was on his feet. "Your Honor, I object to the characterization." "Mr. Holt." Judge Wynn's voice was quiet. She held up one hand. That was the moment. The room went still. And then I stood up. I don't know, even now, exactly what compelled me. Margaret had not told me to stand. She looked at me with a slight widening of the eyes that meant, "What are you doing?" But I stood, and I looked at Judge Wynn, and I said, "Check the timestamps." 3 words. Judge Wynn raised her hand. "This proceeding is recessed," she said. "Counsel, my chambers, now." The recess lasted 45 minutes. I sat in the hallway outside Judge Wynn's chambers with Margaret, who was doing something on her tablet and not talking, which I had learned was how she processed. The hallway had a water fountain that made a faint mechanical sound every few minutes. I counted it. I had nothing else to do with my hands. Daniel and Holt were in a separate waiting area around the corner. I could not see them, but I could hear, once, the low, urgent quality of voices through a door. When the court reconvened, Judge Wynn's expression had not changed. She still wore the same professional neutrality. But something in the room's atmosphere had shifted, in the way a room shifts when a decision has been made, and everyone present can feel it even before the words arrive. In light of the evidentiary concerns raised during today's proceeding, Judge Wynne said. I am referring Mr. Mercer's financial declaration to the court's financial examiner for a full audit. I am also noting for the record that the document in question appears to have been modified within the discovery period in a manner inconsistent with the certification of accuracy Mr. Mercer's counsel submitted. She paused. Mr. Holt, your client should be aware that submitting a materially altered financial declaration to this court constitutes a serious legal matter that will be addressed separately. Holt said something quiet and formal. His white teeth were not visible. On the custody question, Judge Wynne did not rule from the bench that day, which Margaret had told me was normal, that she would issue a written ruling within 2 to 3 weeks. But what she said in court was this. Based on the documentary record presented today, the primary caregiver history in this family is clearly established. I am returning the children to the petitioners. She looked at me. To Mrs. Mercer's primary residence, effective immediately, pending the written ruling. Emma and Tyler came home that evening. The written ruling arrived 18 days later. Margaret called me at work between patients and read it to me in the break room. Primary physical custody, Rachel Mercer. Parenting time for Daniel. Alternating weekends and 1 weekday evening per week. Child support calculated based on the audited income figure, which was $31,000 higher than Daniel's declaration had stated. Margaret's voice had its carefully managed quality through most of it, but at the end she said, Rachel, this is a very good ruling, and I could hear that she meant it. The financial audit went further than I had expected. The court examiner found that the cash withdrawals, $9,000 spread over 6 weeks, were not documented as marital expenses and could not be accounted for. Combined with the hotel charges and the income discrepancy, Daniel's attorney faced a formal sanction from the court. Gregory Holt received a written reprimand from the Illinois Attorney Registration and Disciplinary Commission for certifying a materially inaccurate document. It wasn't disbarment, but it was a mark that follows a lawyer's name. Daniel was ordered to pay Margaret's fees for the second phase of the proceeding, based on the court's finding that his financial disclosure had necessitated additional discovery. There was a moment, about 3 weeks after the ruling, when the reality of it settled in. I was at the school pickup line, which I had been attending for 9 years, which I had documented in a log, which now existed in a permanent court record as evidence of my parenting. Emma got in the car first and said something about a history project. Tyler climbed in after her and immediately began telling me about a documentary about submarines he had seen in class. I drove home through the tree-lined streets and listened to both of them talk at once. What had I built? A record. A paper record of ordinary love. Every receipt for cough syrup, and every appointment confirmation email, and every Wednesday afternoon on Washington Street with Dr. Flores. It had not felt like building anything at the time. It had felt like surviving. But it had also been, in the language the law could hear, an argument. An accurate and irrefutable argument. Daniel did not appeal. I think he had been advised not to, or had run out of appetite for a fight that had already cost him more than he'd calculated. He moved into a smaller apartment in a neighboring town. He exercised his parenting time, which the children managed with the resilience of children who have been loved consistently and told the truth. Crystal Howe, I learned later through Julia, who had a colleague in Daniel's building, had ended their relationship approximately 3 weeks after the ruling. I don't know the details of that. It wasn't mine to know. The blue front door was still blue. It is now 2 years since the ruling. My life did not become luminous. It became mine, which is better. I went back to full-time at the dental practice. I make more money than I did before, and the money is my own. And these facts produce a quiet satisfaction I would not have understood 2 years ago. Emma is 11 now. Serious, funny, full of opinions. Tyler is 9. His speech has continued to improve, and his latest assessment showed he is functionally within normal range for his age. He still identifies clouds by shape. I still agree with him. Julia and I have dinner every other Wednesday. I've started cooking again. Something I had quietly stopped during the worst of the marriage and hadn't noticed until I started again. My sister Diane visited in the spring. We sat on the back porch until 11 talking about nothing in particular. The house feels more accurately mine. I repainted the front door that summer. I kept it blue. As for Daniel, he is living in a rental apartment in Lille, parenting on alternating weekends, occupying the narrowed space his calculations created. He is not a villain. He is a person who lied and who lost things because of it. Crystal left the firm in December, around the time Daniel's legal situation became professionally visible. She relocated. What her life looks like there is not something I think about. What I do think about is this. 18 months after the ruling, Tyler climbed into my car after school, dropped his backpack, and said, "Mom, I have to tell you something that happened in math today." I said, "Tell me everything." That is the life. That is what it turned out to be. 3 words stopped a courtroom. But they only meant something because of 14 weeks of logbooks, 9 months of statements, 1 hotel record, and 1 pediatric file from December. The truth doesn't simply come out. It comes out when it is documented, organized, and delivered at the right moment. If something in your life doesn't feel right, keep your records. The ordinary facts of your days are not small. They are evidence. Now I want to ask you something. What would you have done standing at that window? Tell me in the comments. Subscribe if this reached you. Thank you for listening. Rachel,